How long does a personal injury claim or medical negligence claim take in Ireland? Hi, my name is Grace Carroll and I'm a member of the team here in McMahon Goldrick Solicitors. We specialise in dealing with catastrophic injuries, or also known as life-changing injuries. The timeframe for resolving a catastrophic injury claim is not exact, as each claim is unique both in respect of the nature of the injury itself and how it occurred. However, there are some time limits that are applied when processing each part of the claim, and I will break those down in a moment. Very generally, a catastrophic injury claim will take in the region of 3 years to resolve. However, as mentioned, that is dependent on a range of factors. Very generally, a birth injury claim can take in the region of 3 to 5 years to resolve, as we are often required to observe the course of the development of the child over a number of years. From the outset, it should be noted that the statute of limitations requires an adult claimant to issue proceedings 2 years less 1 day from the date of sustaining their injury. There are some limited exceptions to this rule, and you can see further information on those exceptions on our website. When claiming on behalf of a child, however, a parent or guardian can issue proceedings at any point in time up until the child's 18th birthday. Thereafter, the young adult has 2 years less 1 day from the date of their 18th birthday to issue proceedings in their own right. I will now break down the individual timeframes for processing each stage of the claim. The first step involved in bringing about personal injury proceedings is to make contact with the solicitor as soon as possible. Your solicitors will then commence an initial investigation into the matter. They will ask you to provide them with your formal instructions, which will include details of the injury and accident, medical details, and details of the alleged person or party at fault. Your solicitors will need to review the relevant records and evidence relating to the injury. For example, they will look at the medical records and if there's any CCTV footage available, Garda reports, etc. It can take a number of months for all of those records to be issued to the solicitors, and therefore it is advisable for you to request those records as soon as possible to speed up that process. Once your solicitor has reviewed all of the relevant information, they will then advise whether or not it might be worthwhile to pursue a claim for compensation. The time frame for the solicitor to complete this initial investigation is unknown, as it is dependent on the nature of the injury and of course the solicitor themselves. However, your solicitor will endeavour to complete this investigation as soon as possible, particularly in the case of an adult claimant, as they will be mindful of the 2-year time limit to issue proceedings. The next step is for your solicitor to issue a Personal Injuries Assessment Board or PIAB application on your behalf. This step will not be necessary if your case involves medical negligence or your injury is psychological in nature. PIAB is an individual state body who assesses claims outside of the courtroom. They recommend an amount of compensation that should be provided, if any. If either of the parties disagree with the level of compensation suggested, then PIAB will release the claim so that compensation can be pursued through the court system. PIAB can take up to 9 months to assess the application, and the statute of limitations clock is paused during this time frame. However, in the case of catastrophic injuries, PIAB typically immediately release the application so that the matter can be dealt with by the court system from the outset, as it is too complex a claim for them to process. If PIAB does decide to assess your claim, then you can expect to wait a period of 7 to 9 months for them to assess your claim. You will then have a period of 28 days to accept or reject their recommendation. As mentioned, if either party disagrees with the level of the recommendation provided, then PIAB will release the claim for it to be dealt with through the court system. When the claim is released from PIAB, the statute of limitations will commence 6 months after the date of release. The next step is to establish liability and causation. Before your solicitors will issue proceedings in court, they will obtain at least one expert report to establish whether or not your injury was sustained as a result of someone else's or another party's negligence. The speciality of that expert will depend on how the injury arose. For example, if you sustained a personal injury in a car accident, that expert might be a forensic engineer. But if you sustained your injury as a result of medical negligence, that expert must be a medical doctor. The types of experts involved in catastrophic injury cases are very specialised, and therefore there are not a lot of them around. As such, these experts usually have a long lead-in time and may take a number of months to receive their reports. Once a supportive liability and causation report has been obtained, your solicitors can then formally issue proceedings in court. This is the very first step of formally getting your case up and running. Proceedings for catastrophic injury cases are typically issued in the High Court. Your solicitors will then start to obtain a variety of medical and quantum reports to build up your case. This process can take a year or sometimes longer depending on the nature of the injury. Medical reports are obtained for the purpose of detailing your current condition and your future prognosis from a medical perspective. If appropriate, some of these reports will be obtained from your treating doctors, such as your GP, your neurologist, or your rehab consultant. Quantum reports are the reports that your solicitors will use for the purpose of building up the bulk of the value of your claim for compensation. Quantum experts can include physiotherapists, occupational therapists, care consultants, housing experts, assistive technology experts, psychologists, vocational assessors, etc. These experts will make a number of recommendations to help you live a more independent life moving into the future. Finally, an actuary will review all of those quantum reports to calculate the total value of those future recommendations and your past losses. The solicitors for the defendant will typically obtain like-for-like reports. This means for every type of expert that your solicitor will send you to see, the defendant will arrange for you to see an expert of the same profession for them. The defendant's experts will also ascertain your past and future needs. When both sides have obtained all of their expert reports, the legal papers can then be finalised and your legal team will then be ready to conclude your case. The absolute vast majority of cases end up settling outside of the courtroom. Settlement meetings usually last a day or so. It must be said that a case is never guaranteed to not go to trial. It is difficult to say how long a case might take to resolve if it does proceed to court, as it can depend on how busy the courts are at any particular point in time. But as I said, the vast majority of cases do end up settling outside of the courtroom. So in conclusion, as an adult claimant, you have 2 years less 1 day from the date of sustaining your injury to issue proceedings in court. If you're hoping to claim on behalf of a child, you can issue proceedings at any point in time up until the date of their 18th birthday. It is very difficult to put an exact time frame on resolving a catastrophic injury case as the factors vary so much. But on average, it can take roughly 3 years to resolve a catastrophic injury case and 3 to 5 years to resolve a catastrophic birth injury case. If you would like further information, please feel free to contact us anytime or have a look on our website. And thank you for watching.